Hello and welcome to the 2018-2019 Hearing Officer Training Update designed for persons who have completed the 5-hour basic training for hearing officers and tribunal members. This update is sponsored by the Georgia Association of Educational Leaders and the Georgia Department of Education Policy Division. First topic to be discussed in today's update is self-defense. In 2017, the Georgia Supreme Court offered an opinion with regard to the case S.G. v. Henry County that clearly defines the use of self-defense as a plea in a student fighting case. There is nothing in Georgia law that prevents a student from arguing that they participated in a school-based fight in an act of self-defense. In the S.G. v. Henry County case, the Supreme Court ruled that if a student claims self-defense, it is the student's responsibility to prove that they acted in self-defense. Hearing officers and tribunal members should always consider self-defense claims and may rule in the student's favor based on the self-defense claim if the student is successful in proving they clearly acted in self-defense. The State Board of Education has supported well-proven claims of self-defense when the cases have been appealed. One of the most difficult issues for school administrators is dealing with students who present themselves in their office after they have, quote, found a weapon, unquote. It is a problem when students find weapons or turn them in claiming that they have found them or that they were given the weapon by another individual. School authorities have to make an insightful determination as to whether the student is truthful in reporting finding a weapon as opposed to being in possession of the weapon. In cases where doubt exists, proof remains with the student. Please be reminded that the case law coming out of the State Board of Education is that intent must be determined in order to expel a student for possession of a weapon. They have to possess the weapon with the intent to do harm to others or to intimidate or threaten others in the use of the weapon in order for the student to be expelled. One of the issues that modern school administrators have to deal with is students that have been incarcerated or who have been sent to RYDC facilities. The question comes about is, when does the 10-day clock start in terms of determining when the hearing must be held? Students that have been sent to YDC or who have been incarcerated do not forfeit their right to a due process hearing. The hearing must be held within 10 days of the notification as specified in 20-2-754. If the notification is provided before or while the student is incarcerated, the hearing must proceed within the 10 days even if the student is not present. Please be aware that parents can request that the hearing be delayed, and that is a mutual decision between the school and the parents in any delayed decision for a hearing. If the student is not suspended pending a hearing before incarceration, the student may be suspended pending a hearing upon his return from incarceration. School leaders are advised to take the route of suspending the student pending a hearing upon return from incarceration so that the student may be present for the hearing. In both cases of suspending before or upon return, in both cases, the hearing may be postponed or rescheduled with the mutual consent of the parents and the school. One of the thorny issues that we have to deal with now is the possession of medical marijuana. Georgia Law 16-12-191 provides that persons may be in possession of medical marijuana under limited circumstances defined in the law. Because of federal law, parents should make other arrangements for administering medical marijuana at school and students should not possess the marijuana at school themselves. The reason is that the federal law has not changed, and the possession of marijuana in any form continues to be illegal. It is advised that the parents bring the medical marijuana to the school and administer it to the student. The medical marijuana should not be left in the possession of a nurse, nor should it be kept by the student. The parents should bring it to the school when the drug is to be administered, and they should administer it to the student. Disciplinary action directed towards students in possession of medical marijuana must be addressed by local Board of Education policy and should be addressed in the student handbook. One of the issues that school administrators are having to deal with more and more often is the issue of students being arrested for off-campus felony activities. Georgia law gives school systems a precise method for dealing with students that have been charged with off-campus felonies or activities for which they would be charged with a felony if they were an adult. When the student is processed as far as a hearing is concerned, in that hearing it is not necessary to prove the felony charge, only that the student has been charged with the felony. The testimony of a school resource officer should be sufficient in those cases. The following is a suggested procedure for dealing with students that have been charged with off-campus felonies or who have been charged with offenses that would be a felony if they were an adult. The school superintendent may notify the parents and student that they will be placed in the alternative school until they are adjudicated. If the student or parents object to that, then a due process hearing is held and they may be placed in the alternative facility once that hearing has been held. But that again follows precisely what is found in 20-2-768. Again, the superintendent only has to notify them that the student will be placed in the alternative program until they are adjudicated. Once the student is adjudicated, once they have been found guilty of a felony, they may be expelled or placed in the school's alternative program following a due process hearing. Again, all is necessary to prove is that the student has been convicted and of the felony, and that information should be readily available from the court system. If permanent expulsion is the desire of the local school system, it is recommended that the principal of the school to which the student would return should testify in the hearing that the return of the student to the school would threaten the safety and the security of the school. And if that testimony is given, then it is possible to permanently expel the student. Because of the events of 2018, there have been more and more terroristic threats made against schools and against students in the schools than we have ever seen before. This major issue of dealing with students making terroristic threats towards the schools or students, commonly by social media, is covered under Georgia Law 20-2-690.1. And that law indicates that the student may be permanently expelled or expelled for a specific period of time if they are found guilty of making a threat against the school or making threats against people in the school. Such expulsion should be made only after a due process hearing. Of course, the parents may sign a waiver in such circumstances. It is important to note that a Hall County case, Major versus Georgia, dictated that from the Supreme Court that and upheld a school system's authority to charge or expel a student making a terroristic threat on social media. One of the most difficult issues that we have to deal with in elementary school discipline is what to do with students in grades K through 5. The 2018 General Assembly passed House Bill 740, which has been signed by the governor and prescribes the methods and processes that we are to use in disciplining students grades K through 3. Under the law, K through 3 students may not be suspended out of school or expelled for more than 5 days per year without the RTI process, MTSS process being in place. That is a per year basis. 5 days per year out of school, more than 5 days out of school suspension, more than 5 days expulsion. In order to do that, you have to have the RTI MTSS process in place. The State Board of Education policy defines alternative school as grades 6 through 12. Legal counsel has recently ruled that since it is not prohibited by the law, K-5 students may be served in an alternative school for 6-12 students if there is a local board policy that permits such. Once again, the ruling of the legal counsel was that because the law does not prohibit it, we may proceed as long as there is a local board policy that permits such. Once again, you may place students in grades K through 5 in an alternative school serving 6-12 students if you have a local Board of Education policy in place. One of the serious issues that we have to deal with, particularly at the high school level, is what to do with expelled students. Well, prior to June 30th of this year, students could be referred to the Graduation Achievement Charter High School, which actively recruited and accepted students that were expelled. No other Georgia public school may accept expelled students with the exception of state charter school commission schools. This includes Mountain Charter, Foothills Charter, Coastal Charter, Georgia Connections Academy, and the K-12 Academy. The Georgia Connections Academy and the K-12 Academy are online virtual schools. They may accept expelled students. No other Georgia public schools can accept expelled students. I have given you the contact information for the Georgia Connections Academy because they currently have several expelled students enrolled. One school system has begun an alternative to the Graduation Achievement Charter High School in the way they expel students. The students are expelled with the opportunity to participate in the system's online platform, which is offered through their alternative school. The student may not come on campus, and all contact is limited to email, telephone, or online communication. This may be an opportunity for some school systems. If you're interested in exploring this particular operation for expelled students, do not hesitate to give me a call. Please be aware that the Georgia Association of Educational Leaders offers a helpline for you with regard to school discipline. All you have to do is call 770-601-3798 or contact me via email, and that's jstokes@gale.org. We'll help you in any way that we possibly can. All you have to do is give us a call or give us an email, and we'll give you the advice of what's going on across the state with regard to the matter that you're dealing with, or help you find the correct answer. Once you have completed this 15-minute update, please send an affidavit that you have done such to Jimmy Stokes at jstokes@gale.org. You will be added to the database of hearing officers that have completed the training as required by State Board Rule 160-4-8-.15. You will be notified that you have completed the required training for the 2018-2019 school year. Educators that have not completed the basic 5-hour training can do so through training that will be provided through your local RESA. Please contact your RESA as to when the training will be provided in your area. The training will also be available at the summer and winter Gale conferences. Thank you so much for your participation in the 2018-2019 Hearing Officer Update.